We were studying this section 20 explanation, which I explained to you by making that graphical representation, that where there is sole office, solitary office, single office of a corporation, and cause of action arises anywhere, then which place will have jurisdiction? The sole office. The sole office. The sole office will have jurisdiction in that case. स्टार्ट नहीं हुई अभी, ये कह रहे हैं नॉट येट. We were studying this section 20 explanation, where I said that that there are three possibilities. There are three possibilities where a corporation has a sole office and cause of action arises anywhere. Then which place will have jurisdiction? It is sole office which will have jurisdiction. Then there is second possibility, that there is sole office as well as subordinate office. Sole office as well as subordinate office. And cause of action arises not at subordinate office, but anywhere else. Not at subordinate office, but anywhere else. Now in that situation, which place will have jurisdiction? So, now sole office means single office, sole office. Corporation has sole office. Then I said cause of action arises. Where cause of action arises? This is first possibility, anywhere. Place of suing, sole office. This is the first possibility. Second possibility, there is principal office, principal office. plus subordinate office. So there is principal office. Sole office means single. This is the second possibility. There is principal office and then there are various subordinate office. And the cause of action arises at principal office. At principal office. Anywhere, the second possibility, but not at subordinate office. Then where the where the place of suing will be? Principal office. Now here it is all right. I can also watch my lecture on my mobile phone. So everything is now some people may have some problem of connection, so please check that, because if there is any issue, we'll be also able to know it, because I also watch on my mobile phone at the same time and I log like a student. So it is working all fine. It is working all fine. I'm waiting. Please, you refresh your app and log in again. Then we'll begin. No issue. Thank God. What about others? Should I proceed now? So if a corporation has sole office, this is the first point, and cause of action arises anywhere, place of suing will be at sole office. Now, second situation, I said there is a principal office and there are many subordinate offices. One principal office and many subordinate office. Like I can say that Delhi has principal office and there are many subordinate offices like at Ahmedabad, Bangalore, Calcutta, ABC. But cause of action arises at Chennai. Chennai doesn't have any subordinate office. So where the place of suing will be? It is at principal office. If cause of action arises at principal office, obviously principal office. If cause of action arises anywhere but not at subordinate office, then again principal office. There is third situation where there is principal office plus subordinate office. Now cause of action arises at subordinate office. At one of subordinate office. At one of subordinate office. Now in that situation, where cause of action or where place of suing will be. So it says at that subordinate office, not at other subordinate office. This is very clear. At that subordinate office where cause of action arises. So these are the three things which is required to be kept in mind. So you can write this also. Number one, you just write down. Number one, in case of corporation, in case of corporation, in case of corporation, in case of corporation which has sole office, which has which has sole office and no subordinate office, which has sole office and no subordinate office, no subordinate office. Sole means that there is one office. यहाँ एक ही ऑफिस है, सोल का मतलब एक. No subordinate office. And cause of action arises anywhere. Cause of action arises anywhere. कहीं भी cause of action हो रहा है. Place of suing will be sole office. Because there is only one office, sole office. Sole means single. So place of suing will be at that place. Now number two. So I said in case of corporation which has its sole office and no subordinate office, and no subordinate office. In that case, place of business will be, in that case, the first situation, in that case, place of business will be deemed to be, place of business will be deemed to be place of business will be deemed to be where sole office is located. Is this clear? Is this clear? Then there is second situation where a corporation has principal office and many subordinate offices. Many subordinate offices. Cause of action arises either at principal office or anywhere, but not at subordinate office. Not at subordinate office. Then the place of business will be, then the place of, so you write down, in case of corporation having its principal office as well as subordinate offices, then in such a case, if cause of action, then in such a case, if cause of action arises either at principal office, either at principal office or at any place, but not at subordinate offices. But cause of action arises either at principal place or principal office or anywhere, but not at subordinate offices. But not at subordinate offices. Then in that situation, place of business or suing will be, place of business or suing will be place of business of suing will be principal office. Place of business or suing will be principal office. Now then there is third situation. Then there is third situation where corporation has a principal office where 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 corporation has a principal office and many subordinate offices, and cause of action arises at cause of action arises at cause of action arises at one of subordinate offices. Cause of action arises at one of subordinate office, then place of suing will be at that subordinate office. Then place of suing will be at that subordinate office. And how did we reach to this interpretation? Let me tell you, in explanation of section 20, we have written a corporation shall be deemed to carry on business at its sole or principal office in India. That is clear. Or in respect of any cause of action arising at any place where it had also a subordinate office at such place. Such place here means the place of subordinate office. Such place means place of subordinate office and not principal office. Not principal office, because it is written after or, and or is disjunctive. Or. So if there is principal office or sole office where cause of action arises, then there is no issue. But when cause of action arises at subordinate office, then whether it will be principal office or subordinate office, so law says it will be subordinate office. It will be subordinate office. This is the point. This is what we are required to learn. Now then there is another question related to these questions. Let's see, jurisdictions are provided in section 15 to 20. That is clear. 15 to 20, and that we have already seen just now. 15 to 20, and I don't think that you should have any issue in section 15 to 20 as such. And if you solve the questions, it will be more clear. So section 15 to 20 basically confers territorial jurisdiction on the court according to established principles and practicality and convenience. Now then there is a question, can parties confer jurisdiction on court? Can parties confer jurisdiction on court? This is the question. Answer is that as far as civil jurisdiction is concerned, it is prerogative of parliament, it is prerogative of legislature. As far as jurisdiction of court is concerned, it is prerogative of legislature to confer or oust the jurisdiction. To confer or oust the jurisdiction. And it has been done, and it has been done by CPC as per section 15 to 20 along with section 6. Section 6 is peculiar jurisdiction, this is territorial jurisdiction. Right, and further, in this context, it is clear that the parties can neither confer, parties cannot confer, you write like this, parties cannot confer jurisdiction on court, parties cannot confer jurisdiction on court even by agreement. Parties cannot confer jurisdiction on court even by agreement. Parties cannot confer jurisdiction. Parties cannot confer jurisdiction on court, and any agreement by which they confer jurisdiction on court, and any agreement by which they confer jurisdiction on a court where the court does not have jurisdiction, as per CPC, as per CPC, as per CPC will be considered, as per CPC will be considered void. As per CPC will be considered void. Because that will be against law or statute. Against law or statute. Change the para and then write down. Change the para and then write down. Change the para and then write down. At best, parties can select. At best, parties can select a place of forum parties can select a place or forum of suing, parties can select a place or forum of suing. Parties can select place or forum of suing out of different alternative jurisdiction available in CPC. There are cases to that effect. There is a case Hakam Singh versus Gammon India Limited. Hakam Singh versus Gammon India Limited. I have written in your barract also. Hakam Singh versus Gammon India Limited. AIR 1970, Supreme Court 740. The Supreme Court held that it is not open to parties by agreement It is not open to parties by agreement to confer jurisdiction on a court which does not possess, which it does not possess. Under Civil Procedure Code. Under Civil Procedure Code. Which it does not possess under Civil Procedure Code. Hakam Singh versus Gammon India Limited. Oh, sorry, this is 1971. AIR 1971 Supreme Court 740. Is this all right? This is 1971. So what it says basically, I must tell you, Hakam Singh versus Gammon India Limited, that see, it is not permissible for parties to confer jurisdiction on a court which CPC does not provide. Suppose CPC provides, as you have seen in section 20 and 16, that there can be various courts. That court A, B, C, D will have jurisdiction. Suppose this is provided in CPC. Now question is that X and Y, two parties, can they confer jurisdiction on E court, that is fifth court, A, B, C, these are four courts which have jurisdiction. So can you confer jurisdiction on fifth court? That is the question. The answer is no. It is not allowed. Now question is, what is allowed? It is not allowed. So what is allowed? So out of courts A, B, C and D, parties can choose one or more courts for dispute settlement, for dispute resolution. That is permitted. 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 In other words, they can say that see, A, B, C, D court have jurisdiction. There can be various possibilities. They can say A court will not have jurisdiction, B will not have jurisdiction, C will not have, it will have. Or there can be other possibility that A will not have jurisdiction, B will have, C will not have, D will have. This is permitted. A will have jurisdiction, B, C, D will not have. This is permitted. C will have, A and B and D will not have jurisdiction. This is permitted. Or they can say A or B will have jurisdiction, C, D will not have jurisdiction. This is permitted. So something like that. These all are permitted. These all are permitted. But what is not permitted? You can't confer jurisdiction on fifth court. You cannot say that this will have jurisdiction and this will not have. This will be against CPC. It will be against CPC, that is law. And can you have agreement against law? The answer is no. This is permitted. These first four situations are permitted. This is permitted. This is permitted, this is permitted, this is permitted. But it is not permitted. You cannot confer jurisdiction on fifth court. This is not permitted. This is not permitted. This is what the law says, that out of four courts which have jurisdiction as per CPC, you can provide various alternatives, but you cannot confer jurisdiction on the court which is not provided in CPC. It is not allowed. It is not allowed. Is this clear? It is not allowed. I have already clarified yesterday that in matrimonial disputes you have Family Courts Act or Hindu Marriage Act where jurisdiction is provided, so we'll not look into CPC for that purpose. Now, suit in respect of contract, section 20 has already clarified, but I must tell you, suit in respect of contract, the place where contract was made, many places, the place where contract was made, number two, the place where contract was to be performed, place where payment of money was to be made, these all are places where cause of action arises. These are places where cause of action arises. So the places where cause of action arises will have jurisdiction. Suit in respect of partnership. Suit in respect of partnership. Where agreement was entered into. Number two, business of firm is carried on. Number three, accounts of partnership are maintained. Or now there may be a unique situation where partnership is resolved in foreign country, dissolution occurs in foreign country, and partner resides in India. So in that situation, even Indian courts will have jurisdiction. We are not concerned with the question that the dissolution occurred outside India. Now, before I go to the next point of objection as to jurisdiction, I give you liberty to ask me question on section 15 to 20 right now. Now, henceforth, we'll do the questions along with the topic itself. Anything which you are not able to understand and solve, please let me know right now. I will answer it right now. I will see and I will answer it. Not very long question because it will not be feasible right now, but short questions can be raised and asked. Is this clear? So you ask questions, I take little bit break. So you have many questions. Can section 19 be said as extension of proviso of section 16? Unique question. Sorry. Very unique question. Sir, as far as I understand, as far as I understand, that section 16 deals with the immovable property, no? And section 19 is dealing with different domain altogether, no? Suit for compensation for wrong to person or movable. So there is no connection whatsoever between the two. What is subordinate office? Subordinate office means the office which is subordinate to the main office. There can be many big companies which have a large, structure. So it has a main office at one place, and there can be various offices. Like now, Reliance Industries is a big company. So can it operate from one place? The answer is no. So in that sense, obviously it will have main office at Mumbai, let us say, and many subordinate offices in entire India. Maybe at Ahmedabad, maybe at Bangalore, maybe at Delhi. So various places will be having subordinate offices. Provision of A and B of section 20 looks like same in language. What is the difference? The dependent or each where more than actually involuntarily resides, carry his own business. Now they are not same in language. I have explained to you. I will request you to concentrate in class. I said that, see, where there are multiple defendants, subsection B says, where there are multiple defendants and any one of them has objection, then how will you resolve that issue? See, I am a plaintiff and I am filing a case against three defendants, A, B, C. A lives at Ahmedabad, B lives at Bangalore, and C lives at Calcutta. So if I file suit at Ahmedabad, obviously person from Bangalore and Calcutta will have objection. So how will you resolve that matter? So now in that case, you have to seek leave of the court. It is the duty of plaintiff to seek leave of the court, or the other defendant should acquiesce. It means the defendants at Bangalore and Calcutta must acquiesce in this fact. Acquiesce means basically that they will give their tacit consent. So if suit is filed in Ahmedabad, then the person from Bangalore and Calcutta participate in that without any objection. So that is what is acquiescing. Or you can seek permission of the court, leave of the court. So A doesn't talk of this. This is only in B clause. So there is difference between the two. डिपेंडेंट को ज़्यादा लिबर्टी है उसको प्लेस पर नहीं, नहीं ऐसा कुछ नहीं है ना. प्लेंटिव को इसलिए हमने कहा कि यू गो टू डिफेंडेंट्स प्लेस फॉर द सिंपल रीजन that if plaintiff is not asked to visit the defendant's place, then plaintiff can file false, frivolous, vexatious cases at his place, at his whims and fancies. So if plaintiff takes pen and goes to defendant's door and he files the suit there, it shows that the plaintiff is little serious. And obviously, if his claim is perfectly all right, he will get cost of the suit also later on. This is provision, there is provision in CPC which allows cost to the plaintiff. If he has a reasonable case, if he has a genuine case, and if he gets relief from the court, then the court will look to conduct of defendant and plaintiff and will award the cost in the suit. And that cost, if plaintiff's claim is genuine, reasonable, then the cost will be awarded to the plaintiff. So if he has suffered any expense, etc., he'll automatically get it. So that is why it is now defendant's place. Once more, any illustration with regard to section 18 when jurisdiction is uncertain. Now, jurisdiction is uncertain. Now, that is what I said, that whether the jurisdiction is in this area or in that area. Now, sometimes it may happen that I gave you a very perfect example that the river can change its course. And earlier that river was considered the dividing line and it had changed the course. So there can be uncertainty in that situation. I cannot think of better illustration, my dear friend, so I gave that illustration. So if the river changes the course, then there can be dispute between the two that whether this court has jurisdiction or that court. In that case, now see, law is very reasonable and commonsensical. It says you can file case in any court, but you will have to give reasonable support to that. Then okay. Then there is another question. What is the difference between lack of jurisdiction and irregular exercise of jurisdiction? Cause of action and subject matter. Difference between cause of action and subject matter. A cause of action is bundle of facts which you are required to prove to get the relief. The cause of action is basically bundle of facts which is required to be proved for getting relief in a case. But subject matter is something different. Subject matter can be civil, can be criminal, can be, now as we read in section 9, section 9 deals with subject matter. That whether it is civil or not, whether it is a suit of civil nature or not, that is what is subject matter. Subject matter. Cause of action relates to those facts. Facts are not subject matter. Subject matter can be civil, criminal, revenue, industrial. No, that is what is the hint. Cause of action is bundle of facts which you are now. Suppose there is a contract case, so you are required to prove that there was a contract. Contract is breached by a particular party. How it is breached. So these are the cause of action on the basis of which you can claim the relief. Now, Abhishek, I hope, Karan, I hope, Anas, I hope, Jeba, Agarwal, you are clear on the point which you raised. Simran, why suit merely of recovery of rent from lessee not come under section 16D? Now, what is this? What did you ask me? Now see, section 16 is for immovable property. No? It is for immovable property. And that immovable property is subject matter. The property is situate. See, section 16 says, after F shall be instituted in the court within local limits of whose jurisdiction the property is situate. So it is not for money exactly. It is not for money exactly. It is not for money exactly. So that we have now recovery suits. That is not in section 16. Section 16 is basically for immovable property, Divyanshu. In case where plaintiff is having possession in immovable property, does proviso of section 16 applies? Where plaintiff is having possession in immovable property, possession of immovable property, does proviso of section 17 apply? No, I could not get your question at all. It could be asked other way around. I'm not getting your question at all. Suraksha Saksena. Not clear in my mind what you are asking, my dear friend. So we will write this in WhatsApp. I will answer it again very clearly. You will have to frame your question clearly, sir. So please, sorry for that. I could not appreciate your question, sir. So extremely sorry for that. Please write this in your WhatsApp, please. What is the difference between lack of jurisdiction? Lack of jurisdiction means where you do not have any jurisdiction at all. But irregular exercise of jurisdiction, like lower court should have exercised, you have gone to higher court. So higher court will obviously have those jurisdiction which is possessed by lower court. But as lower court is there and law requires that you visit the lowest court, so it is always better that you visit the lowest court rather than going to the highest court or the higher court. So that is irregular exercise. But lack of jurisdiction means that where there is no jurisdiction. Now, the jurisdiction of any subject matter which has value of 2 crore lies to Delhi High Court. And now you go to Civil Judge Junior Division and you get relief from there. Is it jurisdiction? It is lack of jurisdiction. Or section 9, where there is no suit of civil nature and you file a case in civil court. So lack of jurisdiction. Court cannot decide. Such a case will be now zero, nullity. Lack of jurisdiction. There was no jurisdiction with the court. But irregular exercise, like now, the court has jurisdiction, like higher courts have jurisdiction in the matter which is, you might have read even in CRPC, that superior officer possesses the power of lower officers. But generally for filing a complaint or FIR, you will go to SHO, not to DCP. That is the situation. Lack of jurisdiction where there is no jurisdiction at all. Irregular exercise of jurisdiction, you have jurisdiction but you should not exercise it because you are higher court. Shivangi Khattar, if cause of action arises in Calcutta and business was carried in Delhi, which court will have jurisdiction? Now, both courts will have jurisdiction. It is very clearly written in your this Bear Act. You have read this, Shivangi. Please look into the provision. It is written. Both courts will have jurisdiction. There can be multiple courts which can have jurisdiction. No issue about that. After sale of property, seller has left some link or attachment. Link or attachment means, then why not plaintiff file suit at that? No. What is this question? It is clearly written. Now you see in section 20 also, at the time of commencement of suit, Kasis Munjal. If in between ongoing case, if defendant shifts to another state, then in that case jurisdiction will be at that place where he is residing at the commencement of suit. Section 20 says it, Kasis Munjal. I think I have answered. In view arbitration agreement, parties decide to settle dispute in some other jurisdiction. I don't think so. You cannot confer jurisdiction. Arbitration is not guided by CPC first of all. Arbitration law is not required to abide by CPC or evidence law as such. They are independent. They can formulate their own principle. Arbitration is basically by mutual agreement. That is not court proceeding. We are not going to civil court. So CPC is not attracted in that case. So that question doesn't arise here at all. Nishant Kumar. Arbitration, the idea which I have read it way back in my student days. So I remember that arbitration is CPC or Evidence Act does not apply in arbitration at all. So that is not guided and goaded by CPC at all, Nishantji. No, party cannot, party can confer jurisdiction there, yes. Arbitration, it is your choice. It is your choice, sir. Parties can confer jurisdiction there. Section 20 is residuary in nature. Praveen Yadav, you can say like that, yes, yes. We can say like that. So I hope that we have covered this part. I hope that we have covered this part. I hope we have done it. I will come to your material question later on, don't worry. I will come to your material question later on, not right now. Material question I will come to later on, because I am preparing my own answers so that I take lesser time. Material question we will do later on. I will ask you, so don't worry. I am preparing my answer, so just wait. Just wait, I'll give you answer. Sometimes you write such language which is not comprehensible. Is personal obedience greater than where situated property is local jurisdiction? I could not understand it. I could not understand it at all. I do not understand it. Other suit in section 20 will include all suits which is not covered in now, like contract is one example. Is it written above? No. 16F, what is the issue in 16F? Let us see 16F. Why many people are asking 16F, what is there? Then I'll come to objection 16F, for recovery of movable property actually under distrent or attachment. Movable property actually under distrent or attachment. Sometimes it can be under, now court attaches your property. So that is one very simple example. Court attaches your property. You might have read execution if you have little bit idea. Court can attach your immovable property, court can attach your movable property, but in movable property it cannot attach certain things like your earning tools and your basic utensils, clothes. It cannot attach, but other things it can attach. So that is movable property under attachment, or movable property under distrent. Like now some animal has entered into my farm and it has destroyed my crop there, so I can obviously keep it under distrent. That is not attachment. Distress damage fugent, we call it also like that, where we claim damages and then we say that then we'll release and relieve your animal, not before that. So that is distress damage fugent. Distress damage fugent. Material question I will come little later, don't worry, my dear friend. Distress damage fugent. Now what does it mean? It means that a person whose property is destroyed by some animal, etc., then that animal is kept under, now what is the language? Distrent for recovery of damages to property, for damage to property. Is this all right? Section 16F. And as we move further, you will keep on improving and learning, but sometimes I cannot understand the language, so you can write that in WhatsApp so that I can read it carefully. So, are we clear about this? Just see section 21 onwards till section 21 onwards till section 25. Just have a glance. I want you to see it beforehand, before I read it. Before I read it, I want you to see this. Is this all right? You please see section 21, 22, 23. So let us see this section 21 onwards. Objection as to jurisdiction. In section 21, we are talking of 3 objections. No objection as to, now you can write down this heading, objection as to jurisdiction. Section 21. Then I see it says no objection as to place of suing shall be allowed by any appellate or revisional court unless such objection was taken in the court of first instance at the earliest possible opportunity in all cases where issues are settled at or before such settlement and unless there has been a consequent failure of justice. So it basically tells you that what is the now what can be the stage when this objection can be raised? What can be the stage? No objection as to the place of sowing. So section 21(1) talks of place of sowing. No objection as to place of sowing shall be allowed by any appellate or revisional court unless such objection was taken in the court of first instance at the earliest possible opportunity. So where it should be taken is stage. So it says court of first instance, there you raise this at earliest possible opportunity. At earliest possible opportunity. Court of first instance at earliest possible opportunity. And in all cases where issues are settled at or before settlement of issue. As the moment issue is settled, then the trial begins. Order 14 of CPC. So why don't you raise objection of place of sowing beforehand? Why do you want to allow the court to start the trial process? Can you achieve anything by this? No. Rather, you will be wasting time of the court, wasting resources of the country. So why don't you raise it at the earliest possible opportunity? So no objection as to place of sowing shall be allowed by any appellate or revisional court unless such objection was taken in. So you first have taken objection in court of first instance. If they did not allow your objection, and then you can visit appellate or revisional court in that sense. All right. Then second, it says no objection as to the competence of court with reference to pecuniary limits. So 21(1) is place of sowing. 21(2) is pecuniary limits. Same point. At the earliest possible opportunity. So here you just change this, and you just change this. Objection as to pecuniary limits. Objection as to pecuniary limits. Objection as to pecuniary limits. Is this clear? Objection as to pecuniary limits. Is this clear, my dear friend? And unless there is additional condition, in all cases where issues are settled, unless until there has been consequent failure of justice. So you will have to show that there is consequent failure of justice. Then only the appellate or revisional court will look into the matter. So in both cases, you are required to see consequent failure of justice also. Then third says no objection as to the competence of executing court. Executing court. Objection as to competence of executing court. No objection as to competence of executing court with reference to the local limits of its jurisdiction shall be allowed by any appellate or revisional court unless objection was taken in the executing court. Here objection in executing court because it is matter of execution. So you raise objection at the first instance, that is executing court, at the earliest possible opportunity. So always you raise objection at the earliest possible opportunity. This is number one. At the earliest possible opportunity. Plus consequent failure of justice. So appellate or revisional court will look into the matter when you will show that I have raised objection at the earliest possible opportunity in the court of first instance. In other cases, the court which is hearing the matter in 21.1 and 21.2, and in this case, in the executing court itself, no, at the earliest possible opportunity, and there has been consequent failure of justice. So now I can say fundamentally that appellate or revisional court will entertain objection if following conditions are satisfied. Number one, objection was raised at earliest possible opportunity. Objection was raised at earliest possible opportunity. At or before settlement of issue. Because once issues are settled, then the trial begins. So you are wasting the time. So you should do it as soon as possible. And there has been consequent failure of justice. Consequent failure of justice. Is this all right? Is this all right? Now this rule is basically based on this rule is basically based on maxim vigilantibus non dormantibus vigilantibus non dormantibus jura vigilantibus non dormantibus jura subvenient, which means that law supports only those who are vigilant and not those who are dormant. It means basically that law supports only vigilants who are alert Vigilant means alert or agile and not dormant. It means basically that law supports only vigilance and not dormant. It means basically that law supports only vigilance and not dormant. Law supports only vigilance and not dormant. Now, Section 21A, which has been inserted in 1976, says that bar on suit to set aside decree on objection as to place. No suit shall lie challenging the validity of a decree passed in a former suit between the same parties or between the parties under whom they or any of them claim litigating under the same title on any ground based on an objection as to the place of suing. No. So you cannot file a suit where you can challenge the validity of decree passed in former suit where you have raised objection as to the place of suing. So this um, objection as to place of suing will not be entertained or will not be a ground to question the validity of a decree. To question the validity of a decree. So the point is very clear that validity of a decree cannot be questioned in later suit. Validity of a decree passed in former suit. Decree passed in former suit, which has been decided first. Validity of a decree passed in former suit cannot be questioned in later suit. Cannot be questioned in later suit. Validity of a decree passed in former suit cannot be questioned in later suit. Cannot be questioned in later suit on the ground of objection as to place of suing. So this cannot be the ground for challenging the validity of a decree. This is a bar. Bar on suit to set aside decree on objection as to this is bar. If the decree has been passed, so validity of decree cannot be challenged on this ground that the place of suing was wrong. Place of suing is basically a matter of convenience. It's a matter of practicality. But if the similar court has decided the matter somewhere else, this is not going to now create much problem. Is this clear? Section 21A? So it says former suit means previously decided suit, though it may have been instituted later. So even if it is instituted later, if it has been decided fast, so it is called former suit for this purpose. This can be a preliminary question, nothing great in this. See, then section 22 onwards, there is discussion on uh, uh, transfer of suits. Section 22 to 25, it basically talks of transfer and withdrawal of suits. Section 22 read with 23 enables the defendant to apply for transfer of suit. Section 22 says, let's see, there is, I said section 22 to 25 enact the law regarding transfer and withdrawal of suits, how it does. So let me tell you, let us begin with this. I said section 22, you can write down little bit, read with section 23, enables defendant to apply for transfer of suit. Read with section 23 enables defendant to apply for transfer of suit, while section 24 empowers High Court and District Court and section 25 empowers Supreme Court to transfer suit or appeal either upon application by the party or suo motu. So section 22 read with the section 23 enables the defendant to apply for transfer of suit. So if there is any objection, you can ask for the transfer, that this is not right court, that is right court. And section 24 empowers High Court and District Court, and section 25 empowers Supreme Court to transfer suit or appeal either upon application of by the party or suo motu, on its own. Suo motu means on its own. Either the party will apply or the court will do it on its own. So this is, I hope you appreciated this point. Just a minute, hold on, just a minute. Give me 2, 3 minutes. I am coming back. I'll complete this section 25.